I recognize the Minister.
G159.
Order G159, second reading of Bill 159, an Act to amend various statutes in respect of consumer protection.
Back to the Minister.
I move second reading of Bill 159, an Act to amend various statutes in respect of consumer protection.
Stop the clock for just a moment. Will all members please come or go quietly and quickly so we can continue with debate, please, and thank you. I will go back to the Minister of Government and Consumer Services, please.
Okay, thank you, Speaker. I'm happy to rise today in the House to begin debate on Bill 159, the Rebuilding Consumer Confidence Act. Speaker, I'll also be sharing my time today with my parliamentary assistant, the member from Sarnia-Lambton. And I also want to note, if this bill should pass, this will be MPP Bailey's 7th bill that he's been part of.
Hear, hear.
I really appreciate all the work that he does. I'm very proud of him. And there's a powerhouse right there from Sarnia-Lambton. But Speaker, back to the bill. When I introduced this bill before the holidays, I remember thinking about the incredible range, the diversity of issues that my ministry deals with, things that are important to the people of Ontario in their daily lives, things that are easy to see every day, and they range from easy to see to those that people typically don't even notice, those things that they just assume are getting done right by people who care. And I'm always impressed by the people I work with who really care about getting the job done right. The Ministry of Government and Consumer Services is really a diverse ministry that touches the lives of people when they're shopping at the mall, renovating their home, or traveling on vacation or for business. We're responsible for a significant part of numerous technical sectors, including electrical safety and other technical standards as well. And of course, I would be remiss if I didn't also mention the work that the—
Stop the clock, please. I apologize to the Minister. I am unable to hear your remarks, and I'm looking forward to hearing the debate this afternoon. Would all members who are staying in the House please listen respectfully or remove themselves to have a conversation elsewhere? Thank you. I apologize to the Minister. Please continue.
Thank you very much, Speaker. I appreciate that. So our ministry is responsible for a significant part of numerous technical sectors, including, as I mentioned, electrical safety and other technical standards as well. And I also want to share with you, we do a number of things behind the scenes so that other ministries can get their work done as well. Things like procurement, pay and benefits, IT, and real estate management that most people never see. And have you ever been to the Archives of Ontario on the campus of York University, and I hope if you haven't, you all will, we're responsible for that as well. In fact, Speaker, the Archives has a display called Animalia, and it chronicles the way our relationship about animals have changed over time. It's a good show, and again, if you haven't been to the Archives, maybe think about going there at York University. All of these examples, Speaker, are so important to the very work that Ontario government does, and I'm very pleased to be part of it. So, Speaker, I'm especially proud to bring forward this bill, which, if passed by this legislature, would strengthen protection and enhance business practices for the people of Ontario, at home, online, and in our communities. Speaker, at the time of the introduction of this bill, I said, the people of Ontario need to feel confident that there are strong protections in place when they spend their hard-earned money. And this is why we're changing outdated rules and taking a digital-first approach to deliver stronger protections that are responsive to the needs of consumers while fostering the continued growth of a thriving economy for this province. We're continuing to move forward with a plan to work smarter by putting consumers first. And Speaker, we have been very busy. In the past few months, we have taken a number of very important steps to strengthen consumer protection while reducing burden on business. These include introducing Bill 145, known as TRESA, the Trust and Real Estate Services Act 2020, which the legislature, and I appreciate it very much, recently passed, and this legislation was proclaimed yesterday by the Lieutenant Governor. And we modernized together, 91-0, together this House has modernized rules for registered real estate brokerages, brokers, and salespersons. Regulations will need to be developed to support bringing Bill 145 into force, and once the Act and related regulations are in force, they will better protect people when buying or selling real estate. And I want to thank, again, everyone in this House, the stakeholders and the public for their input to that very important piece of legislation. And thank you to my opposition critic. I felt we worked very well on this legislation together, and it is appreciated. So, again, as we're talking about collaboration, I really want to make sure that people understand that consumer protection shouldn't be colored by any dot or stripe. We all need to work together to move and modernize and adapt to our realities in 2020. And one of the things that I did when I first became Minister of Government and Consumer Services was take a look at changes that had to be made to the rules under the Vintners Quality Alliance Act, 1999. So essentially, we reduced red tape for that sector, and we provided more flexibility to wineries across the province, expanding choices for consumers and for the vintners. One of these changes was adding the Marquette Hybrid grape variety to the list of allowable grape varieties to be eligible for the Vintners Quality Alliance Ontario approval. This was really important because as our wine industry grows across Ontario, we have to make sure that we have varieties that are adaptive to our growing conditions. And so now we have wineries in Huron County and Bruce County, in Prince Edward County, and they all use this Marquette grape. And this variety is very thankfully now recognized by the Vintners Quality Alliance. And it's good. It allows people to realize their dreams in terms of being able to produce good quality wine in their backyard, or in their backfields, I should say, and make other Ontario wines a possibility close to home in Midwestern Ontario or Eastern Ontario, as well as Niagara. Speaker, as we progress on our work, the government is listening to the needs and concerns of consumers to help better protect them. Throughout 2019, the government consulted with the public and stakeholders on 3 main pillars that will help us as we move forward on all of our work. And it will help all ministries as we work to make government faster, smarter, and more efficient. These are 1, protecting the privacy of Ontarians, 2, enabling businesses to compete digitally, and 3, enabling better, smarter, more efficient government to help inform the creation of Ontario's digital and data action plan. Feedback from these consultations will help the government develop an efficient and effective action plan to protect consumers in Ontario. In addition, we'll also be conducting a review of the Consumer Protection Act, the first comprehensive review in almost 15 years. It's badly needed. And this will provide people with an opportunity to share their ideas about how the Act can keep pace with today's marketplace and further strengthen consumer protection. Since Bill 159 first received reading in December, Speaker, we took a bit of an unusual route to get it to second reading by sending the bill immediately to committee for public hearings. It's not unheard of, but it's not the typical roadmap of a bill becoming law. Usually a bill will be referred to committee after second reading, but in this case, I want to demonstrate that the voice of Ontarians matter. I want to hear from them. I want to demonstrate that our government is committed to listening and ultimately taking action. But in this case, with regards to Bill 159 particularly, because the bill covers so many different areas that are so important to people in so many parts of their lives, we wanted to give as many opportunities as possible for people to offer feedback before debating the merits of the bill. And so I just want to take a moment to acknowledge the work of the Standing Committee on Justice Policy for their recent work in clause-by-clause consideration of the bill. And of course, for the public hearings they held across Ontario during the intersessional break. And hearings like this, I can't stress enough, getting input from people about how the bill can strengthen business practices while protecting consumers and keeping Ontario open for business is so, so important. And I should also note that I think it's great that the committee took time to go outside of the GTHA and travel the province. Life could be very different, and I think it's important that we get outside of the GTHA and enable people the opportunity to have their voice heard as well. One of the things I hear most often is, people are getting tired of the cookie-cutter approach and decisions always being made at Queen's Park that don't necessarily connect and reflect the realities outside of the metropolitan area. And I think that people, as we took 159 across Ontario, really appreciated the fact that we went to Windsor and we went as far east as Ottawa. During that time, we heard from 27 individuals and organizations in those meetings, and I want to thank everyone who participated. Their feedback genuinely made this bill better. So let's talk about one of the aspects in the bill, Ontario new home warranties. And we're proposing changes. And with that in mind, Speaker, I want to talk about some very specifics with regards to new home warranties. A bit earlier, I mentioned TRESA, Trust in Real Estate Services Act 2020. When Bill 159 was being considered, I heard from a number of people that they wanted to also see improvements to Ontario's home warranty and protection program. So I want to address that first. I know this is one of the biggest items members will want to discuss in this House. The bill we're discussing now, the Rebuilding Consumer Confidence Act 2020, would, if passed, amend the Ontario New Home Warranties Plan Act and the New Home Construction Licensing Act 2017. The need for change in this area is as obvious as it is urgent, and it has been for many years. I've said it before in this House, buying a home is the largest investment many Ontarians will make in their lifetime. But the current program for the delivery of new home warranties and protections absolutely does not meet the needs of consumers. We have heard that some Ontario families are buying new homes with serious defects, putting their health and safety at risk. We've also heard consumers are frustrated and, quite frankly, are fed up with this slow and complicated warranty and protection claims process that feels stacked against them. They want to be confident that they are hiring a reputable company to build their home, and in that regard, expect strong warranties and protections that they can depend upon as well. They want strong oversight and enforcement of clear rules for builders. Today, some Ontario families are buying new homes with serious defects. Quite simply, the current warranty and protection system, it was broken, and we're addressing it because it had been broken for many years. And through this bill, we're going to keep moving forward in terms of addressing concerns. Our government proposes to fix that broken program and restore consumer trust by protecting what is most likely the most important, as I said, purchase in a lifetime. We're also responding to recommendations made by the Auditor General in the special audit of Tarion Warranty Corporation by taking steps to make significant improvements that would make the Ontario New Home Warranty and Protection Program more responsive to the needs of consumers. In relation to new home warranties, our changes proposed in this bill would firstly overhaul the new Ontario, or let me start that one again, overhaul the Ontario New Home Warranty and Protection Program to make it consumer-focused by enhancing the current single administrator model for the administration of warranties and protections. A new and improved warranty and protection program is anticipated, if this bill passes, to be launched as early as this fall of 2020. And second, it would support new consumer protection priorities that the government committed to last spring as part of the overhauled program. This includes enhancing the dispute resolution process and delivering new measures to promote better-built new homes. With regard to the dispute resolution process, this bill also includes proposed changes to the Ontario New Home Warranties Plan Act. And these changes would, first of all, establish a new mandate for Tarion to promote the resolution of claims as soon as reasonably possible. It would also provide Tarion with the ability to use a range of processes to resolve disputes between homeowners and builders or vendors. This is very important. We would also see the balance restored for consumers. This would happen by removing builders and vendors as parties at the License Appeal Tribunal in disputes between homeowners and Tarion over warranties and protection claims, unless regulations specify otherwise. And it would enable the government to prescribe adjudicative bodies other than the License Appeal Tribunal to resolve disputes between homeowners and Tarion over warranties and protection claims. Further, Speaker, if the legislation passes and we see Rebuilding Consumer Confidence Act move through this House, my ministry plans to publicly consult on regulatory proposals that would be required to bring in some changes into effect. This would include further measures to enhance dispute resolution. Speaker, we all know how important it is to have an effective and consumer-focused new home warranty and protection program in Ontario. And that's why our government conducted focused consultations this past spring with key stakeholders, including the insurance industry, consumers, home builders and vendors, subject matter experts. We looked at what was happening in other Canadian jurisdictions, as well as Tarion. Based on research and consultations, the government has decided to continue with changes to a single administrator model rather than moving to an insurance model. We believe that enhancements to the single administrator model for warranties and the delivery of protections is in the best interests of the people of Ontario. It is also important to note that in the Auditor General's 2019 audit of Tarion, she identified a number of risks with the insurance model, and she found that, and I quote, "The advantages of moving towards the competitive multi-provider insurance model is still unclear." By implementing an enhanced single administrator model, the government would be able to more effectively respond to the issues that consumers raised during recent consultations, such as improving the claims process. People have spoken, and we have listened. Speaker, before I move on, I want to read to you something that the Toronto Real Estate Board said when this House passed Bill 145 last week. I quote, "The Toronto Regional Real Estate Board is applauding Minister Thompson and the provincial government for the successful passage of Bill 145, the Trust in Real Estate Services Act 2020. This significant effort will help enhance professional standards, create a more fair and efficient business environment, and better protect consumers dealing with those who trade in real estate in Ontario." Now, I don't want to take up more time in the House here today on a bill that we've already passed, but I wanted to share that quote because I think it perfectly sums up what we're trying to do in all of our work. Enhance professional standards, create a fair and more efficient business environment, and better protect consumers in Ontario. Mr. Speaker, this is the balance that my ministry is constantly striving for. We're not trying to pit consumers against business. There's nothing to be gained in doing that. Instead, we're looking at finding solutions that will work well for consumers by creating a fair and competitive marketplace. And at the same time, we're helping good, honest business people by not having to compete with bad actors. In the end, I think that is what we all want, balanced and reasonable solutions. So another aspect of the Bill 159 addresses administrative authorities, accountability, governance, and transparency. So I want to speak about that a little bit today as well.
Great job so far.
Thank you. Appreciate that. Speaker, there is a wide range of other issues, and specifically the administrative authorities, we're proposing changes that would help strengthen the framework under the government's oversight. For the benefit of the House, Speaker, I just have to take a moment to explain the role of our administrative authorities. These are independent, not-for-profit corporations that operate within a strong accountability and governance framework that are delegated certain responsibilities by the government. They regulate or provide services for specific sectors and industries. Many of the administrative authorities enforce a number of Ontario's laws, including consumer protection and public safety laws, and they also investigate alleged violations and they handle complaints. For example, some of these administrative authorities are responsible for helping ensure that certain professionals Ontarians get service from are qualified as well as competent. Some of these professionals are involved with equipment we use in our daily lives, such as elevators. These are people who make sure the equipment is properly maintained and that consumers are being educated about their rights when making certain purchases as well. They do all of this without receiving any funding from government. The administrative authorities are financially self-sufficient and raise their revenues through the fees they charge to the sectors they are responsible for. Many of you may be familiar with administrative authorities such as the Electrical Safety Authority, the Travel Council, or I'll say that one again, the Travel Industry Council of Ontario, the Real Estate Council of Ontario, and the Retirement Homes Regulatory Authority, among others. The model works. It works well for the most part. Government retains its lawmaking, regulation, and oversight roles while giving the administrative authorities the responsibility for daily operations of how to best carry out their mandates. This includes things such as licensing and enforcement, amongst other matters. Bill 159, if approved, would harmonize, and I think this is really important, Bill 159, if approved, would harmonize some key accountability, governance, and transparency requirements for most administrative authorities that the government oversees. The changes would increase the range of tools the government would have to address issues that may arise with respect to the authority's governance and performance. If the changes, if passed, would affect the following administrative authorities specifically: the Technical Standards and Safety Authority, the Electrical Safety Authority, Bereavement Authority of Ontario, the Real Estate Council of Ontario, the Ontario Motor Vehicle Industry Council, Travel Industry Council of Ontario, Condominium Authority of Ontario, Condominium Management Regulatory Authority of Ontario, Retirement Homes Regulatory Authority, and the Resource Productivity and Recovery Authority. These administrative authorities are each accountable to one of three different ministers. Myself, the Minister of Government and Consumer Services, the Minister of the Environment, Conservation and Parks, as well as the Minister for Seniors and Accessibility. Speaker, these authorities currently operate under a patchwork of legislation and laws that govern them. They vary. Again, we need to tie up some inconsistencies and make sure our administrative authorities are working well under the same umbrella with the same expectations. Some authorities right now are subject to stronger accountability, governance, and transparency requirements, and while others are not. This means that the current models may not provide the government with the tools it needs to quickly and effectively address governance or performance issues that may arise. We believe that it's important to have consistent rules across the administrative authorities, and our bill reflects that. These proposed amendments would do that for the most of the administrative authorities the government oversees. Right now, there are some important differences in the way people get information or services from these authorities as a result of inconsistencies. Making these requirements consistent would help ensure that the public gets the same baseline of information and services from our administrative authorities. If passed, this would lead to greater public confidence in the authorities, and that the responsibility that they have will be shown in the sense that they're providing important functions and services that consumers can count on day in and day out. Administrative authorities should be subject to consistent standards and requirements to provide information and services. And at the same time, our government needs to have a consistent range of tools to address issues if they should have, if administrative authorities should actually have demonstrated performance that may not be necessarily desirable. For example, the bill would create more consistency regarding the ability for the Auditor General to conduct value for money audits of most administrative authorities. The bill would also establish more consistency regarding the minister's powers to support good governance of certain administrative authorities. This would include giving the minister authority to appoint the chair from among the directors of the administrative authorities board. It would also allow the minister to increase or decrease the number of directors on the actual board. The minister would also have the ability to limit representation of specified persons or classes of persons on the authority's board of directors, and could set competency criteria for the directors of a board. And lastly, the minister would be able to establish rules about the nomination of board members, their appointment or election process, the length of their terms, and whether they may be reappointed or re-elected. Speaker, this bill would also give the minister authority to require certain administrative authorities to establish one or more advisory councils and include certain representatives, such as public representatives. Or we could also require authorities to undertake an advisory process. Additionally, if passed, the bill would establish more consistency regarding the transparency requirements for most administrative authorities. And this would include giving the minister the power to require the administrative authorities to publish compensation information on their website about board members, officers, and employees. In addition, the bill would put into place requirements for the administrative authorities to make their bylaws and annual reports available on their websites. And it would require administrative authorities to publish on their websites their fees, costs, other charges and payments, and the process and criteria under which they were established. Transparency is paramount. Speaker, the government remains committed to the administrative authority model, but there was room for improvement. And again, I want to emphasize the fact that we remain committed to the administrative authority model, but I think it's prudent for the government to have these powers that I just discussed if our responsibility for public interest is to be meaningful. Speaker, I think our administrative authorities do good work, but however, there are conceivable scenarios where the government might have to take additional extraordinary steps if certain conditions are in place so we can protect the public. The bill would establish more consistency regarding the minister's ability to appoint an administrator to the administrative authority as well. An administrator, if appointed, would have the right to exercise all of the powers and duties of directors, officers, and members of the administrative authority for a temporary period of time. This bill would also allow the minister to issue policy directions to an authority, require changes to an authority's objects or purposes as well. And the bill would allow the minister to unilaterally amend an authority's administrative agreement. Again, these powers could only be exercised under specific conditions. Conditions where this power could be exercised are in cases where the power is necessary to prevent serious harm to public safety or to the interests of the public or consumers. The administrative authority in question is facing a risk or insolvency, or the board does not maintain a quorum. So I think what we're suggesting in terms of advancing transparency and governance in our administrative authorities is going to be well received. But now let's talk about consumer protection. So, Mr. Speaker, so far I've talked about a number of important areas for consumers and businesses, but I also want to share with you that our proposed legislation makes changes to the new home warranty and protection program and the rules for administrative authorities, as I said, but we also need to think about consumers. When we think about consumers, most of us think immediately of shoppers at the mall or maybe online where people buy goods and services. Even though most purchases don't ever compete with the value of the purchase of a new home, a vacation, or the importance of the safety of the electrical work in our walls, many other transactions are more frequent and top of mind. When you're thinking about the value of your reward points, considering canceling a contract, or just fed up with people trying to sell you something at your door, these are the day-to-day issues that more often occupy our water cooler conversations. They are the issues that are covered under the Consumer Protection Act, one of my ministry's most relied upon and best known statutes. The Act has served Ontarians well, but things change. And, Speaker, I know the standing orders don't allow me to deliver the rest of my remarks by holding up props, but I'll make my point this way. The economy is moving faster than it ever has before. And we can prove it on our devices, but I won't hold it up because that's a prop. But it's a case in point in almost every sector in this province. And there's hyper-competitiveness, and my ministry wants to ensure that we've got things right, to ensure that we're open for business and we're adapting to the decision-making and the shopping habits of Ontarians. That's why my ministry will be launching formal consultations later this year on an end-to-end review of the Consumer Protection Act to make sure it keeps up with the realities of the modern market. Admittedly, that will be a very involved process, but in the meantime, there are things that we can do right now. The changes that we are proposing in this bill would improve protection for consumers as well as help businesses. By ensuring we have a range of effective enforcement tools, we can encourage compliance with the law and deter bad actors who continue to cause harm to consumers and to the reputation of honest business people. The government needs more tools to respond to non-compliant businesses. What the ministry needs is a tool such as an administrative monetary penalty. This is a tool that already exists in some other areas that my ministry oversees. Currently, the Consumer Protection Act does not allow for them. As we have seen in other areas, these are an effective tool to encourage compliance, and they can be imposed to promote compliance in cases where prosecution may not be warranted. Having this power under the Consumer Protection Act, or CPA, would bring it in line with other Ontario consumer legislation and with other jurisdictions in Canada as well. If this bill is approved, the changes would allow the government to impose administrative monetary penalties against businesses if they do not comply with the specific provisions of the Consumer Protection Act. Regulations would be needed to establish which contraventions of the Act could result in an administrative monetary penalty, set the amounts of the penalties, and make them an effective and workable enforcement tool. And to that end, my ministry will be consulting with the public on proposed regulations that would implement the administrative monetary penalty scheme under the CPA if Bill 159 is passed. Speaker, I think, as in most areas, businesses and consumers essentially want the same thing. They're looking for level playing fields where good, honest businesses do not have to compete with bad actors. I've said this before in relation to real estate professionals during the debate on Bill 145, and I'm saying it again today. We have to ensure that today's marketplace is free from bad actors. People just want a fair shake. I think these amendments would do that. It would be an efficient and ultimately more effective system so that we could weed out some of the bad actors. This would be a new piece to the Consumer Protection Act, so my ministry plans to consult on it very broadly. In particular, we would want to talk with a wide range of stakeholders about the types of infractions that would be subject to administrative monetary penalties and, as I mentioned before, what is the proper sum, what is the proper value of a penalty to be applied. Now I want to talk about ticket sales. Speaker, the final portion of the bill I'd like to address is an amendment to the Ticket Sales Act 2017. The Ticket Sales Act establishes requirements for selling tickets and outlines protections for purchasers of tickets to Ontario events. If approved, the changes would require that all prices be listed and charged in Canadian currency. Currently, ticket businesses are required to indicate when non-Canadian currency is used in an offer. It has to be in a clear, prominent and comprehensible manner. Despite this, consumers may not be aware that the price is in a non-Canadian currency until late in the transaction or when it actually shows up on their credit card statement. And frankly, that's not acceptable. Most tickets listed on online platforms are purchased with a credit card. If tickets are offered in non-Canadian currency, for example, in US dollars, credit card companies may charge a foreign currency conversion fee, which adds to the cost for consumers. For a consumer, this could mean that a ticket they purchase in Ontario for an event being hosted in Ontario could cost them the exchange on the US dollar and their credit card's commission fee, all for an event that's just in their backyard. That needs to stop. Now, Speaker, this is ultimately a consumer's choice, but they should have the information so that they can make an informed choice. The new requirement would support consumers' ability to make an informed choice between ticket offers in Canadian currency and would increase fairness for consumers by ensuring that tickets sold for an event in Ontario are priced and charged in the currency that they expect. Consumers would be able to buy tickets online and know exactly how much their tickets are going to cost them. In addition to these proposed changes to the Ticket Sales Act, we will also be consulting on regulations to improve protection, transparency, and choice for consumers buying tickets. We will also be consulting on new administrative monetary penalties and penalty amounts to discourage bad behaviour in the ticket industry as well. So, Speaker, I think we can all agree that this is quite an extensive bill, but it has not been reviewed for some time. And just like my ministry's business overall, the changes are broad and affect people and businesses in a wide range of issues that they deal with in their daily lives. For example, I know there has been a lot of discussion about Tarion and the new home warranty and protection program alone. Amendments to the bill could probably be enough to fill up our entire debate time. We could just talk about what needs to be done to Tarion alone. But there's, as I mentioned, other important considerations as well. I'd like to also share with you in this House today that our changes would have passed by this House overhaul Ontario's new home warranty protection program. That is a priority. And it would also reform Tarion to make sure that it is more focused on consumers. When consumers get the keys to their new home, they should feel confident that it has been built properly and that any defects will be taken care of in a timely manner. I know we often talk about the purchase of a home as being the largest purchase ever to be made, but Speaker, a home is more than just a purchase. You should feel secure, safe, and comfortable. And so it's just not important that new home warranties and protections help safeguard that massive purchase. The warranty is also important because it helps give that home buyer a peace of mind that mistakes will be corrected and addressed in a timely manner. Our proposed changes to improve the single administrator model for the delivery of warranties and protections would give new home owners a better dispute resolution process and deliver new measures to promote better built new homes. This includes new measures such as providing the warranty administrator with a greater ability to scrutinize builder applications and with a mandate to promote the construction of properly built homes. But, Speaker, this is just not the end of the road in terms of our proposed changes to help consumers and businesses. Our proposals include creating stronger governance and oversight powers over Tarion and other administrative authorities that perform critical functions, including protecting consumers, businesses, and public safety. And quite frankly, I think that they're necessary to ensure that government can safeguard the public interest regardless of circumstance. Speaker, again, I want to thank everyone involved in the Standing Committee on Justice Policy. I appreciate their time that it took to travel this bill across the province, and I appreciate everyone who also participated in the committee hearings last week. Again, I think that this bill will be better because of the input that we gained from the committee process. And again, it was important to me that this particular bill traveled outside of Toronto as well. And so, again, I thank everyone for making an effort to cross the province. If the House passes Bill 159, we will continue working with stakeholders as we move towards implementation. This includes the very important process of developing regulations such as the administrative monetary penalty provisions under the Consumer Protection Act. Speaker, through you to the honourable members, I'm looking forward to the remaining debate, and I hope we can all work together to ensure that Bill 159 earns the same support that Bill 145 did, and I am now pleased to share the floor with MPP Bailey from Sarnia-Lambton.
I recognize the member from Sarnia-Lambton.
Thank you, Madam Speaker, and it's a pleasure to rise today and join the Minister of Government and Consumer Service in the lead-off of the debate of Bill 159, the Rebuilding Consumer Confidence Act. And as the Minister spoke about travel across the province, I was proud to join that committee, and we traveled to Brampton, Ottawa, and Windsor, so among others places. That was a great pleasure to meet people from across the province, hear their concerns, and hear their suggestions. This is the second time in about a week that I've had the privilege of joining the Minister of Government and Consumer Service to discuss one of our terrific pieces of legislation that the Minister and her team have put together on behalf of the people of Ontario. Last week, about this time, we were discussing at third reading Bill 145, the Trust and Real Estate Services Act, TRESA. Bill 145, which passed with a vote of 91 to nothing, was a perfect example of how our government really embraces the consultation process and listens to the feedback we receive. Bill 145 made a number of changes that hard-working professionals in the real estate industry have been requesting for nearly 15 years. I had a lot of interest in seeing Bill 145 pass into law, not only because it was a great piece of legislation that was drafted by the team at MGCS, but because it was also adopted the substance of my private member's bill, Bill 38, the Tax Fairness of Real Estate Professionals Act, which would finally give real estate professionals the ability to incorporate like other professionals. Madam Speaker, I was extremely pleased to see Bill 145 pass its third reading, and I had a great time earlier this week with the Minister and Lieutenant Governor of Ontario when yesterday we actually had royal assent for our Trust and Real Estate Services Act, and so that now is in place, and it was a great pleasure to take part in that. Personally, I think that we have another terrific piece of legislation in Bill 159, the Rebuilding of Confidence Act. I hope that together, the members that are here today recognize in this House that we can move this bill forward with the same success that Bill 145 experienced, with input at committee and from the various members to make it an even better bill. Madam Speaker, the team at the Ministry of Government and Consumer Services, of which I'm a member, really try to do a great job for the people of Ontario. They have a broad scope and range of responsibilities to the government and the people of Ontario. I'm amazed at how well they stay on top of everything. Under this Minister's leadership, Madam Speaker, the team at the Ministry really seem to have their finger on the pulse of the province. As I said a moment ago, Bill 159 is a perfect example of our government consulting, listening and coming forward with an action plan for the people of Ontario. I'm very proud to be part of that team that brought this bill forward. Bill 159, if passed by this legislature, would strengthen the protection and enhance business practices for the people of Ontario, at home, online, and in our communities. Madam Speaker, to paraphrase the Minister's comments from the introduction of the Rebuilding and Consumer Confidence Act, people need to feel confident that there are protections in place when they are making decisions about spending their hard-earned money. We all know how hard it can be to earn a dollar. As a government, we are going to modernize the protections that consumers have in our province to reflect the changes in the marketplace. That is why we are changing outdated rules and taking a digital-first approach to deliver stronger protections that are responsive to the needs of consumers today and into that future. Madam Speaker, there's a lot of important content to this bill that I would like to review with you. But first, I'm going to mention the different path that we have taken with Bill 159 since it was first introduced in December. I was very interested in how our government, after introducing the bill, moved the bill to go to committee immediately for public hearings. I thought that was a unique approach. I've always been a proponent with my private members' bills, of which the Minister mentioned earlier. Thank you for that, of getting them to committee and letting the committee do the work of improving them for the people of Ontario. I think that this is a great approach to take with this government legislation as well. Works with private members' bills, it can certainly work with government legislation. I also had the opportunity as the parliamentary assistant to the Minister of Government and Consumer Services to sit in on the committee that traveled the province with the bill. We traveled to Brampton, Windsor and Ottawa for hearings on Bill 159. It was very informative to get input from the people about how the bill can strengthen business practices while protecting consumers and keeping Ontario open for business. Madam Speaker, I certainly learned a lot at these hearings. In total, we heard from over 27 individuals and organizations in those meetings. Their feedback has helped us improve this bill, and there's no doubt about that. The new Ontario Home Warranties Plan that I should touch on here right now, I think, if I could just find it. Anyway, first, I believe that every member of this legislature has been hearing from people asking for improvements to the government's new Home Warranty and Protection Plan. Bill 159, if passed, will amend the Ontario New Home Warranties Planning Act and the new Home Construction Licensing Act. The need for change in this area is as obvious as it is urgent, and it has been for many years. Buying a home is the largest investment many Ontarians will make in their lifetime. But the current program for the delivery of new home warranties and protections does not meet the needs of consumers in this day and age. Buying a home, but the current program for the delivery of new home warranties and protections does not meet the needs of consumers. As my colleague, the Minister of Government and Consumer Services, said earlier in her remarks, we have heard that some Ontario families are buying new homes with serious defects, putting their health and safety at risk. Consumers are frustrated and are fed up with a slow and complicated warranty and protection claims process that feels stacked against them from the get-go. Madam Speaker, I've met with many of these people to discuss these ongoing concerns. They really do feel they're in a helpless place under the current system. What they're asking for seems very reasonable. As the Minister said, individuals want to be confident that they are hiring a reputable company to build their home and expect strong warranties and protections that they can depend on. They want strong oversight and enforcement of clear rules for builders, but that's not happening in today's environment. Quite simply, the current warranty and protection system is broken, and it has been for many years. The need for change is as obvious as it is urgent. As the Minister stated, through this bill, our government proposes to fix that broken program and restore consumer trust by protecting what is most likely the largest purchase that they will ever make in their lifetime. We are also responding to recommendations made in the Auditor General's special audit of Tarion Warranty Corporation, by taking steps to make significant improvements that would make the new Ontario Home Warranty and Home Protection Program more responsive to the needs of consumers. In relation to the new home warranties, our changes proposed in this bill would, 1, overhaul the new Ontario Home Warranty and Protection Program to make it consumer-focused by enhancing the current single administrator model for the administration of warranties and protections. A new and improved warranty and protection program is anticipated, if this bill passes, to be launched in the fall of 2020. In addition, it would support new consumer protection priorities that government committed to last spring as part of the overhauled program. This includes enhancing the dispute resolution process and delivering new measures to promote better-built new homes. With regard to the dispute resolution process, this bill also includes proposed changes to the Ontario New Home Warranty Plan Act. If passed, these changes would, establish a new mandate for Tarion to promote the resolution of claims as reasonable as possible. It would provide Tarion with the ability to use a range of processes to resolve disputes between homeowners and builders or vendors. 3, very important, it would restore balance for consumers. This would happen by removing builders and vendors as parties at the License Appeals Tribunal in disputes between homeowners and Tarion over warranties and protection claims, unless regulations specify otherwise. And 4, it would enable the government to prescribe adjudicative bodies other than the License Appeal Tribunal to resolve disputes between homeowners and Tarion over warranties and protection claims. I think these steps, if passed by the legislature and by committee at review, would go a long ways to solving a lot of concerns and disputes going forward. Further, Madam Speaker, if the legislature passes the Rebuilding Consumer Confidence Act, the Ministry of Government and Consumer Services plans to publicly consult on regulatory proposals that would be required to bring many of these changes into effect. This would include further measures to enhance dispute resolution. Speaker, as the Minister mentioned in her remarks, we know how important it is to have an effective and consumer-focused new home warranty and protection program in Ontario. That is why, last spring, the government conducted focused consultations with key stakeholders, including the insurance industry, consumers, home builders and vendors, other professionals and subject matter experts, other Canadian jurisdictions, and, lastly, Tarion. Importantly, based on research and consultations, the government has decided to continue with changes to a single administrator model rather than moving to an insurance model. We believe that's a multi-insurance model. We believe that enhancement to the single administrator model for warranties and the delivery of protections in the best interest of the people of Ontario. Madam Speaker, there is no doubt about it that the changes we propose to make to reform Tarion and the new home warranty and protection program make up a huge portion of Bill 159. However, this Act addresses many other issues too, issues that are no less significant to the people of Ontario. In fact, very importantly, many times when people are interacting with the Ontario government on issues, they are actually interacting with one of the many administrative authorities in the province. And many of our constituency offices, I know mine for sure, interacts with a number of these administrative authorities on an ongoing basis. The list of administrative authorities that fall under the Ministry of Government and Consumer Services is quite extensive. There's no doubt that many constituency offices will have experience communicating with some of these agents on behalf of constituents. These agencies include, but are not restricted to, the Electrical Safety Authority, the Technical Standards and Safety Authority, the Travel Industry Council of Ontario, the Real Estate Council of Ontario, the Ontario Motor Vehicle Industry Council, otherwise known as OMVIC, the Condominium Authority of Ontario, and Ontario One Call, which was an administrative authority that rose out of a private member's bill by a member of this, Ontario One Call, actually. And so Ontario One Call is an administrative arm's length authority that continues in this province, and I'm proud to say that now I'll be able to keep an eye on it with even closer than I have in the past, because I've got a vested interest there to make sure it operates well. It's something that most people, it happens every day, just on speaking, anytime you work on your driveway, or you want to put an addition to your house, or a major contractor's doing a little job or a major job anywhere in the city of Toronto or anywhere in Ontario, they deal with one call. They went from anywhere from 23 to 25 phone calls with all the different agencies and utilities. Now they can do it with one phone call through Ontario One Call. So I'm very proud of that bill, and very proud of that administrative agency that is health and safety, and also convenience, cost control for the contractors, and for the cities that administer it. But I could continue, Madam Speaker, but I believe you get the picture. Sorry about that. There are also administrative authorities that fall under the Ministry of the Environment, Conservation and Parks, and the Minister of Seniors and Accessibility, who's with us today. These authorities across all these different ministries currently operate under a number of different pieces of legislation. Some authorities operate under strict requirements of accountability and transparency, and some do not. We believe we can improve that. In the Rebuilding of Consumer Confidence Act, we're proposing to change that patchwork approach to governance, bring it all under one area. We're proposing to have consistent rules across administrative authorities that our government can, and any future government can oversee. Madam Speaker, the Minister mentioned earlier in her remarks a number of the specific changes to administrative authorities that the Rebuilding of Consumer Confidence Act would enable if passed, so I won't repeat them now. But the key message here is that with this proposed legislation, we will be making sure that the Minister has the power, ability, and responsibility to ensure administrative authorities are operating to a standard of governance and performance that the Ontario government and the people of Ontario expect and deserve. Madam Speaker, Bill 159 also proposes changes to the Consumer Protection Act. Changes here are needed because consumer habits are changing. With advances in technology, many people have changed their shopping habits. The Consumer Protection Act is in need of an update to reflect modern consumer behavior. We will be conducting a review of the Consumer Protection Act, the first comprehensive review in over 15 years. We are going to take a look at how the Consumer Protection Act can be updated to strengthen protection for consumers and adapt to changing technology and marketplace innovations. This consultation process will be a big job. While the team at the Ministry of Government and Consumer Services is working on that, we can also make changes to areas that we know need improvements. Right now, a major frustration that I hear about in my constituency office on an ongoing basis from my staff and from constituents who have made complaints to the Consumer Protection Act branch is that the Consumer Protection Act lacks effective enforcement tools. All too often, constituents come to my office with what seems like a clear case of a business or government agency failing to live up to the spirit of the Consumer Protection Act. By ensuring that we have a range of effective enforcement tools, we can encourage compliance with the law, deter bad actors who continue to cause harm to consumers, and to the reputation of honest business people. I've had a number of cases, Madam Speaker, in my office that relate to a number of these agencies, anything from OMVIC to government agencies that don't respond in a timely manner. People are left on hold if they even pick the phone up. So I know this is on the minister and the ministry's agenda. I intend to work with them to make sure that that's looked after. The government needs more tools to respond to non-compliant businesses. The tools that we are proposing to address this under the Consumer Protection Act is administrative monetary penalties. They always say the best way to get reaction is through someone's pocketbook. So I think that when the administrative penalties are in the right circumstances, if they're warranted, that will certainly get people's attention. If Bill 159 becomes law, it would allow the government to impose administrative monetary penalties against businesses that are found not to have complied with the Consumer Protection Act. I think this is an improvement to the Consumer Protection Act that consumers and honest business people will be supportive of. I know I've dealt with many different business people. I think of one major car dealer down home who has told me many stories about his competitors and how it would be easy for him if we made some changes to operate. And he said, but I don't want to see those changes made because I know there's some bad actors out there that would take advantage of that. He said, I like it the way it is. He says, as long as the government is, I got to report to them every month. I have a report. He says, it'll keep me honest. And he said, I know the other operators out there, if they're living on the bubble, we'll get them. I think this is an improvement to the Consumer Protection Act. The consumers and honest business people will certainly be supportive of that. Under ticket sales, finally, Madam Speaker, I will touch briefly on the Ticket Sales Act. It's never been more convenient to purchase tickets to concerts or sporting events or theatre in Ontario. We do it back home in Petrolia many times with the Victoria Playhouse, which has a great summer theatre, and I know my wife goes online and buys tickets from time to time at that, and I wouldn't know how to do it, but she does, and when we show up, we have a seat, and it seems to work. I wouldn't have the faintest idea how you can go about it. Everything can be done with just a few clicks on your phone or your laptop or your computer. That's how consumers in this day and age want to purchase tickets. No longer you have to line up and stand overnight in a line in the rain or something to be there at 4 in the morning when the ticket gate opens at 9. We're going to make sure that our laws protecting consumers in these transactions are modernized and they reflect today's marketplace. Madam Speaker, we're going to consult and then we're going to take action to improve protection, transparency and choice for consumers who are buying tickets to events in this great province. Again, this includes consulting on these new tools like administrative monetary penalties so our ministry can take action if needed against these different firms and businesses. We hope there's no bad actors out there at the end of the day, but if there are the odd one, then we'll certainly be able to take action. In conclusion, Madam Speaker, Bill 159 covers a number of topics that I know are important to consumers in Ontario. Our ministry has made commitments to continue to consult with consumers and stakeholders on many of the changes we are proposing to make in Bill 159. I really believe that the team at the Ministry of Government Consumer Services, led by the Minister, has done an excellent job of putting forward a bill based on what they have heard through consultations across this province so far, and I'm confident that if this bill passes, we will see a very strong consumer protection system in our province moving forward. I think at the end of the day, that's what we all want. Madam Speaker, thank you again for the opportunity you gave me today to speak to Bill 159. I look forward to continuing this discussion in the question and answer portion of the debate. Thank you.
Questions? I recognize the member from Humber River, Black Creek.
Thank you very much, Speaker, and I thank the Ministry for putting forth this legislation. So When government members sat in opposition in the previous Liberal government, they spoke with one voice with the NDP at the time. They listened to what Justice Cunningham suggested, his major recommendations, and they agreed with them. What's happened? What's changed?
Response? Sarnia Lambden.
Device there so I can hear the question. I think that what we heard at committee, what we heard from Justice Douglas Cunningham, we took his report, and I think at the last count we've agreed to implement already 29 of the 37 or 32 of the 37 recommendations. I don't have the number right here in front of me. And we've agreed to implement those already. And the other ones that are outstanding are out there for further study, and I look forward to input from when we get to committee, and as the study is given, we'll take a look at those other recommendations from the Justice Cunningham.
Question? I recognize a member from Mississauga-Streetsville.
Speaker. I did sit in some of the meetings, especially when we talked about Tarion and the warranty program that was undoubtedly, unbelievably left to its own course and did not serve the members of the new homeowners as it was meant to for many, many years. And the makeup of that board was most definitely towards developers and did not help the consumer at all. So my question to the member is, can you tell us a little bit about the makeup of the new board for Tarion and the measures that we took, the swift, immediate measures that we took to make that change to support consumers? Thank you.
Response, the member from Sarnia Lambden.
Member for that question. Yes, that was, when I seen the composition of the old board, the former board, I was quite surprised too by the different composition of it, compensation as well, when we finally found what that was. So the minister immediately, upon taking over the ministry, immediately, I don't want to, well, gave the former CEO, I guess back home we'd say, give him his walking papers, and he left for want of another word. And we also changed the composition of the board, the number of the board, from 16 to 12, and there's a regulation in there from the minister herself that only a limited number of them can be actually home builders or developers. So we changed the composition of the board in that respect to make sure that the appointees and the people will have more influence, and it won't be heavily weighted, in which it should never have been, in the way of builders and developers.
Question? Member from Humber River Black Creek.
Thanks again, Speaker. In the clause-by-clause of this bill, NDP amendments seek to address the issues of board composition. In fact, we had an amendment that said no one can serve on HICRA if they have a real or apparent conflict of interest. If the government is interested in consumer protection on the board and stopping conflicts of interest, why did they vote against this amendment?
Response? Member from Sarnia Lambden.
Speaker. Well, I think at the time I was on the committee, and I think we applauded a number of the motions that were put forward by the opposition party and by the member in question from Humber Black Creek. Spoke to them very eloquently. And what we felt, the builders need to have some presence on that board, because if we're going to hold them accountable and get them to cooperate, we need to have them on the board, have a presence there so we can make them react to change that we want to make. We've changed the composition so they will no longer have a majority on that board, and I think that the new members will certainly get the message that this is what the minister wants. We want accountability, and I applaud the minister for her reactions.
Questions? I recognize the member from Mississauga-Malton.
Madam Speaker, I still remember the first time when I bought the house, and I don't remember whether I had the happiness that we bought a house or we were having the pain of the problem which came with it. And I happened to be with the member in Windsor when we were at the committee, and I heard the similar problems, similar situation. So can the member tell me, as we know, purchasing a new home is one of the most significant investment anyone can make in their lifetime, and many Ontarians have been eagerly waiting improvement to the new home warranty program in this province. Could the member please tell us what our government is doing to enhance the home warranty program in Ontario? Thank you, Madam Speaker.
Response? Member from Sarnia-Lambton.
Thank you, Madam Speaker. Well, thank you, and thank you for your participation on the road when we were in committee. And yes, we did hear many, good stories, but a lot of horror stories as well. So the Act hasn't been looked at for over 15 years, the Consumer Protection Act and the Home Warranty Bill. So when, what we were going to do, I know homeowners have been waiting for a long time because when they make those significant investments in a home, so we've promised to overhaul the Ontario New Home Warranties Protection Program, support the new consumer protection priorities by the government by the spring of 2019, early 2020, and we overhauled the dispute resolution process. And these are in addition to changes that were already made last year, such as board and executive compensation disclosure. So I think what we've created is an environment where Ontarians can have a trust in the home warranty program. Thank you.
Further questions? I recognize the member from Humber River Black Creek.
Again, Speaker. Essentially, this legislation does not change the staffing of Tarion. In fact, all we see is essentially a promotion within the highest levels of management, and the CEO is left. How is Tarion supposed to fix itself when so little has changed within Tarion?
Oh dear.
Response? Member from Sarnia-Lambton.
Madam Speaker. Well, I think that, we know where there's problems there. There's been enough press written about it. The board and the new board, and of course the old board's left, and the employees know that, for want of another word, they're under the gun. They're under a very strict microscope now. There's a lot of changes that are being made within the organization as we speak. They're working to certain timelines, and they know that they have to deliver, and I'll be the first one to be raising that issue within the ministry if they're not delivering.
Question? The Associate Minister of Energy.
Madam Speaker, and truly a pleasure to speak to this bill. As the former minister that was involved, it's great to see my colleague, Minister Thompson, and her very capable MPP and PA, Bobby Bailey, carrying this forward. And Madam Speaker, we've begun the process of setting up the regulatory body outside of Tarion. We've required the public posting of board and executive compensation. We have introduced new measures for prospective pre-construction condominium projects, taken steps to overhaul Tarion's board, and despite the critics saying it's not really a big change to change out management and get rid of the people that weren't really doing the job, and that's kind of like how they backed the Liberals for 15 years, Madam Speaker. They didn't really want to see a whole lot of change. We're actually making change, so I'd like the member to just reiterate why this is such a good bill and how much it's going to actually help protect consumer confidence.
A reminder to all members that we must refer to each other by titles or by ridings and not by cute nicknames or first names.
My apologies.
Response. The member from Sarnia-Lambton.
Thank you, Madam Speaker, and thank you for that correction. And to respond to the Minister, Bruce Gray, Owen Sound, always a pleasure to work with him in the House and work with him on committee, and great leadership he has shown in his different ministry roles that he's taken. Yeah, I think this is, as he asked, why is this such a big change? Well, I think, now Tarion, to be fair, was a ministry, an administrative authority that was created over 40 years ago, long before any of us, even the Honourable Minister from Timmins was even here, and a lot of the rest of us. So, this organization was one of the first, I understand, that was even created by the provincial government, the former Conservative government. And so it kind of grown over time, and I think it kind of grew out of, like Topsy, it kind of grew, and it didn't have the kind of supervision that it's going to have going forward. Thank you, Madam Speaker.
Thank you. There is not enough time for another question and answer. Further debate. I recognize the member from Humber River Black Creek.
Thank you, Speaker.
Order.
Thank you, Speaker. Today I rise as official opposition critic for government services and consumer protection, and I speak to Government Omnibus Bill 159, Rebuilding Consumer Confidence Act 2020 on its second reading. Speaker, somewhere out there, Daniel Brown Emery watches the sunset of his life. Karen Somerville, president of Canadians for Properly Built Homes, or CPBH, told his story to us at the Standing Committee of Justice Policy on January 22, 2020, which is ironic, since his story is anything but just. Here's an excerpt of Daniel's battle with his home builder in Tarion, as told by Karen. In 2007, Daniel bought a newly built home in Port Dover. Daniel quickly found serious construction defects, including Ontario building code violations. He contacted Tarion and he understood that Tarion would help him. He waited for over 3 years for Tarion to help. They did not. His insurance was cancelled due to the construction defects and mold. Without insurance, Daniel could not get his mortgage renewed. Without a mortgage, his home went into foreclosure. In 2011, Daniel became homeless. In 2017, Daniel was diagnosed with throat cancer. His oncologist asked, "Have you ever been exposed to asbestos or mold?" Daniel said that his heart sank, as he had lived in that newly built house with mold for years as he waited for Tarion to help him. Daniel underwent chemotherapy, radiation, and a radical neck dissection. He remained hopeful, but in November 2019, Daniel received tragic news. The cancer had returned. Doctors have told him that he will not survive this time. In a December 14, 2019 Facebook post, Daniel wrote, "I just wanted to build a home to retire in. I paid for Tarion's warranty. I paid the builder in full. Neither of them did what they were legally and morally bound to do. Did they pay a price for their transgressions? No. One could argue I will pay again the ultimate price, my life." He has a son and a wife. On January 6, 2020, Daniel finally had the opportunity to meet with Tarion's senior management after all these years. He asked me to join him, that being Karen, and his wife in that meeting. I was honored to join them. Daniel continues to desperately seek compensation from Tarion. What does the example of Daniel Brown Emery have to do with Bill 159? Everything. It is a tragic example of the need to ensure that Ontario Building Code is enforced during construction, and when it is not, of the need to take swift action to ensure that the proper repairs are made. Speaker, again today, Daniel's cancer is stage 4. I have begun my critique of this bill with Daniel's story, told in Karen's own words, for 2 important reasons. First, just as Karen summarizes, there are dire and often tragic consequences for a failed system of new home warranties. Secondly, it provides a stark contrast of Tarion as opposed to the advocates who are fighting for its bold reform. Tarion, a 44-year-old arm's-length non-profit organization which serves conflicting roles in regulating home builders while administering new home warranties. Tarion, a non-profit organization sitting on $250 million collected ultimately from new home purchasers, which incentivizes its own executive compensation to essentially reject paying out claims for those from whom it has collected its money from. Their outgoing CEO netted $750,000 salary on his last year alone. And then there is Karen from CPBH, a non-profit organization that has existed for 16 years and is run by volunteers. Volunteers who learn the hard way about Ontario's failed home warranty experiment. Volunteers who have chosen not to patch and run when faced with serious home defects, but have stood up to their builders in Tarion. And long after their own warranty issues were either resolved or in many cases sadly abandoned, they have remained to fight for others. Karen and CPBH literally stood by Daniel's side in his fight. CPBH is not alone in their courage to stand up against bad builders in Tarion. You will hear about many other remarkable individuals throughout my submission today. But isn't that the state of consumer protection in Ontario? When the rich and powerful organizations and corporations break the rules, they have sums of money, armies of lawyers, and powerful associations and lobby groups to watch their back. Even worse, the government itself is often firmly in their corner. And who do their victims have? Often nobody but the shoulder of others similarly harmed. It is the age-old story of David and Goliath. But Speaker, as I have said right in the beginning of this submission, I am speaking to a new act proposed as an omnibus by a government who railed against omnibuses when they sat in opposition. But now the government has power, and yet almost 2 years later, we are still waiting for implemented change. Surely amendments to new home construction licensing and new home warranties should be dealt with on its own. But again, as this is an omnibus bill, it opens up many acts in order to bring minor amendments to give the government more control over its delegated authorities. The marginal changes the government made to the acts opened up in this bill could have been much farther reaching. For example, it could have made salary disclosures of all employees of delegated authorities making $100,000 or more mandatory on the sunshine list, rather than simply upon the minister's request. This bill also makes marginal changes to the Ticket Sales Act in order to make it mandatory for ticket sellers to offer their ticket prices in Canadian dollars. But what it doesn't do is take action against ticket sellers who collude with scalpers, resulting in restricted ticket supplies and astronomical resale ticket costs. I introduced amendments during the clause-by-clause of this bill to cap resale values of tickets at 50% of the original cost, as well as curb down on primary ticket sellers holding back tickets to inflate demand and increase prices. The government members of the committee voted against these amendments. Speaker, as I very briefly touched on the other schedules of Bill 159, I return to the elements of this Act that have garnered by far the most stakeholder interest and which require the most urgent change. Schedules 4 and 5, which seek to amend the New Home Licensing Act 2017 and the Ontario New Home Warranties Plan Act. So let's start from the beginning. In 1976, Ontario's government established the Ontario New Home Warranties Plan Act and created its first delegated authority, a non-profit corporation called the Ontario New Home Warranty Plan, to administer it. The Act and this non-profit were created in response to mounting complaints about problems with new home construction. This non-profit was later renamed as Tarion. But as this new Act was being debated, a Globe and Mail article was published on June 19, 1976 that raised serious concerns about its future. The article was written by Jacob Ziegel, U of T professor of law, and was entitled, "Bill Being Rushed So Consumers Won't Be Heard." Reading this article begs the question, was Tarion built to fail? And it is just as pertinent today as it was 44 years ago. I will now read the article here and you can decide for yourself. A home is easily the single biggest purchase made by a family in its lifetime. But as many young couples have painfully learned during the past 3 years, the price of homes is rapidly exceeding their grasp. However, financing the purchase of a home is only one of the headaches Canadians have to contend with. The other is to ensure the house that they buy is properly built, on time and in accordance with the promised specifications. Most consumers know even less about homes than they do about cars, their second largest single investment. Builders, moreover, are not always competent or scrupulous. Some are more interested in making a fast profit than in giving fair value for money. As a result, there has been a rising tide of complaints about badly built homes and builders who do not honor their contractual undertakings. According to federal officials, such complaints have ranked third in frequency of complaints by consumers. Bill 94, the Ontario New Home Warranties Plan Act 1976, is the Ontario government's belated answer to these problems. The thrust of the bill is in the right direction, but it is seriously flawed in one vital respect and suffers from a number of other shortcomings. The bill has four main components. First, it requires all builders and vendors of new homes to be registered. Second, it requires every vendor to warrant the home is constructed in a workmanlike manner with proper materials and is fit for habitation and free of major structural defects. Third, the bill envisages the establishment of a guarantee fund which will compensate an aggrieved buyer if the builder goes bankrupt or otherwise fails to perform his contract, breaches the warranties, or the buyer suffers damages because of a major structural defect. The fund would be supported by the builder's registration fees and fees payable by them on the construction of a home. Finally, and not least importantly, the bill encourages the conciliation of disputes and requires the parties to agree to arbitration if conciliation is not effective. These provisions are neither novel nor objectionable in principle. They are indeed widely regarded as necessary for the successful operation of a warranty scheme. What is without precedent in the Ontario consumer protection legislation is the nature of the body entrusted with the administration of the important powers contained in them. For it is not the Ministry of Consumer and Commercial Relations or any government agency that is entrusted with the task. It will be a non-profit corporation of undetermined composition, incorporated under the Ontario Corporations Act, and at best only indirectly accountable for its actions to the legislature. There's no secrecy about the reason for this feature of the Act. It is a surrender to the long-sought goal of HUDAC, the Housing and Urban Development Association of Canada. The association has argued for several years that warranty schemes for homes should be administered by the builders themselves and that the construction industry should have majority representation on the corporation to be established for this purpose. In earlier discussions involving the establishment of a national home warranty scheme, the federal government refused to accede to this demand. There are strong indications the Ontario government will prove more compliant. Imagine the furor if it was proposed that a consumer-dominated corporation should regulate the construction industry. The right answer, of course, is that no single interest group should dominate the corporation. It should fairly represent all the various groups. And the corporation should be established by statute and be fully accountable in all respects to the legislature. We ought no longer to tolerate the creation of the legislative sanctioned semi-private monopolies exercising important statutory powers. All this is bad enough. Equally objectionable is the government's apparent eagerness to rush this bill through as quickly as possible. The bill should have been referred to a standing committee so the members of the public would have been provided with an opportunity to make representations. Instead, the bill has been referred to the Committee of the Whole House. It is about 4 years since the government first announced its intention of introducing a home warranty plan, and 8 years since the Ontario Law Reform Commission first published its report on the subject. Where so much time has already elapsed, another month's delay would not have mattered. It could only have improved public credibility of the new bill. And so the foundations of Tarion were built on foundations as faulty as the homes built by some of the bad builders they unquestionably issue license to today, who yet often fail to warranty. From Tarion's outset, it has been controlled by the building industry and was tasked to regulate and, when need be, stand up to. And its controlling board would hire an executive team that would adhere to its will, and its executive team would manage a staff that would follow its instructions. But while many of the problems outlined 44 years ago remain, this government, like the Liberal government before them, has had years of reflection and expert information on how to achieve reform. But as I have learned about the state of home warranties in Ontario, many have suggested the problems have only intensified as the builder-controlled Tarion was left to its own devices. Certainly, William Hillier of Cardinal Creek in Orléans shared his own personal experiences at the Justice Policy Committee hearing in Ottawa on January 22, 2020. In 1984, I purchased a new home. Tarion was only a few years old at the time. The builders were edgy when approached by the homeowner with problems and the risk of seeking Tarion's assistance. They responded very quickly. In 1993, I bought another new home. For 2 years after purchase, I haggled back and forth for the builder to complete repairs that occurred during construction. When I finally approached Tarion, I did not get any further resolution to my problems. I took my issues before the tribunal where I lost my case. My speculation at that time was that home builder organizations had infiltrated the Tarion monopoly, so much so that Tarion was empowered for the builder and not the home buyer. In 2017, I once again purchased a new home. I waited almost 2 years for the cleanup of mold and repairs to a leaking basement. I am still fighting with the home builder and Tarion to correct deficiencies in my new home. It should be noted that Mr. Hillier bought 3 new homes throughout his life. Each one required warranty work, yet only one of the homes had its issues resolved without a fight. In committee, Mr. Hillier called for Tarion to be scrapped. Speaker, social media really began in the early 2000s. And with the advent of its channels and platforms, like-minded individuals could reach each other across great distances. Now those individuals who were facing home defects but were told by their builder that they were just being picky or unreasonable could find others just like them. Perhaps it was through a blog or an online publication in a different city or town. It was a tool for individuals to gather in numbers and ultimately strength. It was a tool to collect and share information, and they used it to great effect. Speaker, the previous Liberal government won power during this new age. The advent of the internet, social media, and other online tools enabled many movements to gain otherwise inaccessible information and increase their own membership and build their momentum. I raise this point, Speaker, because I believe the Tarion reform advocacy that reached out to the previous Liberal government now had the means to argue a compelling case that would not have been so easily accomplished in the past. Still, the government prioritized other things, and so its opposition took up the fights of groups like CPBH and individuals like Barbara Kaptein. In the former riding of Trinity Spadina in downtown Toronto, a large number of condominiums were being built, resulting in an unprecedented number of new units falling under the Tarion warranty. Its representative of the time, NDP MPP Rosario Marchese, began hearing from frustrated consumers battling Tarion. I would also like to recognize the important contributions of John Boker, who was Rosario's right hand in his work to reform Tarion. He has been an incredible resource to many of us in the opposition in our work on this important matter. With the backing of Tarion reform advocates, the NDP opposition in Ontario tabled 4 private members' bills, 3 by MPP Marchese and 1 by former NDP MPP and now current federal NDP leader Jagmeet Singh, demanding change in new home warranties. Each time their bills were defeated by the developer-friendly Liberal government. On June 12, 2013, MPP Marchese submitted an article to the Toronto Star entitled, "Ontario must do more to protect buyers of new homes." I will share an excerpt with you now. Who protects new home buyers in Ontario? If you said the Ontario government, you would be wrong. No, when Ontarians make the largest purchase of their lives, their consumer rights are protected by a private corporation called Tarion, which administers the Ontario New Home Warranties Act. If your new home has a cracked foundation, leaky plumbing, or an uneven floor, it is Tarion's job to hold the developer accountable. There's just one problem. Tarion is run by the same development industry it is supposed to regulate. Tarion's bylaws state that 8 of the 15 seats on the Tarion board must be members of the Ontario Home Builders Association, a lobby group for the development industry. Since the New Homes Warranties Act obliges all builders to register with Tarion, the province gives this one lobby group monopoly control over all builders and new home buyers in Ontario. And judging by the regular complaints I receive, it is clear that Tarion's public mandate takes second place to private interests. My constituents have told me of complaints to Tarion about faulty HVAC systems, broken condo elevators, inadequate soundproofing, or leaks through the walls. A true consumer protection agency would have taken action, but my constituents have experienced apparent indifference from Tarion, or an attitude that clearly favors the developer over the consumer. These anecdotal reports are backed up by years of investigations by the consumer group Canadians for Properly Built Homes, as well as decades of consumer reports dating back to 1986, when former Ontario Ombudsman David Hill urged reforms to what was then known as the New Home Warranty Program. Since then, little has changed. Various auditors, ombudspersons, and consumer advocates keep saying the same thing. Tarion is not accountable to the consumer. Meanwhile, around the time of MPP Marchese's article in The Star, a new and large development was proposed in the riding of Orléans. It was called Cardinal Creek Village, and it faced stiff opposition from local residents at its outset, who claimed it would take away one of the best views of the Ottawa River in the city. On June 25, 2013, 2 weeks after MPP Marchese's article in The Star, former Ottawa City Councillor Fran Stronach was interviewed on CBC News about the proposed development, saying, "Whatever the developer wants, the developer gets." And I find that very objectionable. Wow. When asked to elaborate, she simply responded, "Big money talks. Wow. What's the rest of us to do?" Long before the development even appeared in Ottawa City Council, the developer opened up a sales office. Of course, the developer gained the necessary approvals, and 4 years later, Mr. William Hillier, whom we heard about earlier, purchased a home there only to engage in a long battle with the builder and Tarion to have his home warranted for major defects. And as Mr. Hillier was purchasing a home in Cardinal Creek Village, so too were Marcel and Julie Belfay. We will hear their story soon. Under the intense pressure of Tarion reform advocates, consumers, opposition MPPs, and the Ontario Ombudsman, the Liberal government finally agreed to allow a review of Tarion. That moment in time is described in a Toronto Sun article authored by MPP Marchese on November 29, 2015, and it was entitled "Review of Tarion Long Overdue." Here is an excerpt of this article to give you a snapshot of that moment in time. If you haven't bought a new house recently, you may not have heard of the Tarion Warranty Corporation, and you may not care about the provincial review of Tarion announced recently. But if you are buying a new home in Ontario, Tarion is a big deal. After years of complaints by consumers, the Ontario Ombudsman, and by MPPs from all parties, the government finally agreed to a review of Tarion, to be led by respected former Judge Douglas Cunningham. But just as consumers began celebrating their hard-won victory, Consumer Minister David Orazietti prejudiced the review by remarking, "I anticipate that Justice Cunningham will find Tarion's processes validated as good consumer protection measures." So before Cunningham has even hung up his coat, Orazietti has already declared everything is fine with Tarion. That's the Liberals. It looks like Justice Cunningham is being asked to attach his good name to a review that has a preordained outcome. It looks like Justice Cunningham, and Cunningham is no puppet, and he has proven he can navigate complicated and foul-smelling government waters. I still hope he will be able to push back against the government and special interests and get the tools and access he needs to properly investigate Tarion. But even Justice Cunningham may be unprepared for the roadblocks and spin that will certainly be thrown in his way by the most captured regulator in Ontario and by the government that enables it. As you can see, the Liberal MGCS minister of the time was completely deaf to the consumer complaints of that time, simply presupposing that Justice Cunningham would simply report that Tarion was just fine. Thank you very much. It should be noted that PC MPPs joined the lead of NDP MPPs in a call for significant change then. That no longer appears to be the case. What happened to them? A little over a year after that Toronto Sun article was published on December 14, 2016, Justice Cunningham submitted his final report of the new Ontario New Home Warranties Plan Act with an attached letter to the Liberal MGCS minister.
What's her name?
That report, I will tell you, that report did not say business should continue as usual. In fact, it was quite the contrary. Here's an excerpt of his letter to the minister. Dear Minister Lalonde, I have approached this review with an open mind and with no preconceived ideas on what a new home warranty program should look like. I have listened to and engaged directly with many individuals with an interest in Ontario's warranty program. I have read the many submissions received during the review. I have learned a great deal about the complexities of new home construction and about the different roles of builders, lenders, municipalities, and others. I have become familiar with how other jurisdictions deliver new home warranty protection and builder regulation, and with the actual experience of homeowners, builders, and those who work to deliver the warranty protection. And I have heard about the challenges faced when there is a dispute over warranty coverage. In this review of Ontario's new home warranty program, I was faced with the current reality of a corporation, Tarion, and legislation, the Ontario New Home Warranties Plan Act, which have been in place for over 40 years. Tarion continues to operate in a structural framework established in legislation that is 40 years old. That structural framework has assigned it multiple roles, from rulemaking to adjudication. Inevitably, this framework has given rise to real and perceived conflicts of interest and has presented it with challenges in fulfilling its multiple roles. The extensive input I have received in my analysis led me to believe that there is room for considerable improvement, including with the legislation itself. This improvement can best be achieved with significant change to how the new home warranty protections are delivered and how builders and vendors are regulated. So what did Justice Cunningham's report reveal, and what were his suggestions? In his examination of Tarion, Justice Cunningham identified a number of challenges, and I quote, "Tarion's dispute resolution is not always as accessible or effective as it could be. Consumer information and education is not as helpful or effective as it could be in explaining home maintenance, terms of warranty coverage, how to navigate the claims process, and what could be expected with new construction charges to warranty protection as developed by Tarion through processes that are ad hoc and not as transparent and consultative as they could be. Builder and vendor regulation is not consistent with modern approaches to consumer protection regulation, and governance measures intended to provide accountability, transparency, and oversight are not aligned with the modern and current best practices." Justice Cunningham developed 2 overriding and 6 additional objectives to inform his recommendations. He stated that these objectives would, and I quote, "provide clear outcomes and should be reflected in legislation and its implementation." His overriding objectives were: 1, consumer protection, deliver strong new home warranty protections for new home buyers and owners. 2, building quality, promote high-quality residential construction in Ontario and continuous quality improvement. His additional objectives, and I quote, were accountability and transparency, public confidence, modern dispute resolution, inclusive rulemaking and standard setting, a modern regulator, and efficiency. So what did Justice Cunningham recommend based on his extensive examination, based on these well-thought-out objectives? Well, he began by stating that a program that seeks to both build high-quality homes and deliver appropriate new home warranty coverage within a jurisdiction requires 4 essential functions. 1, making rules regarding mandatory warranty protections. 2, administering the warranty program. 3, adjudicating disputes about those rules. And 4, regulating builders and vendors. Under the current Act, Tarion is responsible for all 4 functions at once, prompting Justice Cunningham to point out that this multiplicity of roles at a minimum gives rise to a perception of conflict of interest and can also result in actual conflicts of interest. This, Speaker, is very important, and he further elaborates at an executive level the structure of having the same leadership team responsible for the rules of the monopoly warranty program, financial management of the program, dispute resolution, and builder regulation will inevitably give rise to situations where financial objectives compete with other objectives, such as consumer protection. At an operational level, there is potential for conflict when the same person receives a claim, investigates it, attempts to assist the parties in resolving the claim, and then sits in judgment on the claim, if not resolved. While Tarion has worked to build internal controls to mitigate this conflict, I believe that current controls do not adequately respond to these challenges in a manner that can achieve the objectives outlined above. I do not believe that this problem and the challenges I've identified can be adequately addressed in the current model without significant and structural changes to the new home warranty sector in Ontario. So to properly establish a system that would provide the 4 essential functions he outlined earlier, he proposed a new system with a new home warranty program delivered through a competitive multi-provider warranty system with a separate builder-vendor regulator, independent adjudication of warranty disputes, and rulemaking subject to government approval. Justice Cunningham further provided a detailed roadmap for the establishment of a new system with 37 recommendations, the first of which stated that new home warranty protections should be delivered through a competitive model. In addition, his recommendations spoke to setting minimum requirements, technical competencies, continuing education for builders and those they employ, the establishment of a builder code of ethics, a more robust and transparent online builder directory, far greater consumer education, and much more. As you can see for yourself, Justice Cunningham asked for nothing less than massive change. Under the weight of this heavy report, the Liberal government was forced to act, but rather than truly listen, since Liberal connections to the development industry are as close as Tarion's, they tabled Bill 166, which ignored the majority of Justice Cunningham's recommendations, including many of his most important. The issues of Cardinal Creek Village new homeowners had already begun, which is significant as they happen in the very riding of the Liberal MGCS minister who received Justice Cunningham's review. Not only did she have his expert opinion, but now, firsthand, practical examples of new home construction quality and warranty issues in the very own community she was elected to represent. Still, that appeared to change nothing. But on November 27, 2017, as the ineffectual Bill 166 appeared in committee in the dying days of the Liberal government, a seemingly innocuous amendment was passed by the forward-thinking member of Niagara Falls, who was then NDP critic for government services and consumer protection. That amendment was to allow the Ontario Auditor General to look at Tarion's books for the first time in 44 years of existence. More on that later. Just over half a year later, on June 7th, 2018, the people had decided that they had had enough of 15 years of Liberal mismanagement and waste. For Ontario home warranty reform advocates, this represented a new hope, since Ontario's opposition had been unified in their call for significant reform. In that election, I was elected as MPP of Humber River Black Creek, joining Ontario's official opposition and later becoming critic for government services and consumer protection. With my new role, Karen Somerville of CPBH and Barbara Kaptein reached out to me. I saw firsthand their passion to reform the system for others and their extensive knowledge about the licensing of builders and new home warranties in Ontario. On August 22nd, 2018, CBC's Laura Osman of CBC News Ottawa broke a story on issues happening in Orléans. It was entitled, "Cardinal Creek Homeowners Locked in Battle with Builder." And here's an excerpt from that story. Residents of a suburban housing development in Ottawa's East End say they're worried their new homes are unsafe after discovering major construction defects soon after they moved in. The City of Ottawa confirmed building code violations were discovered in at least 9 homes in the Cardinal Creek neighbourhood after the owners moved in, meaning the new homes didn't meet the minimum standard for health and safety. Different homeowners found issues such as cracked foundations, leaky walls, mouldy basements and garages, and evidence of deer mice. The homeowners have been working with the builder, the city, and regulator Tarion to make the necessary repairs, but it's a slow process. In the meantime, they can't sell their homes, and most can't afford to live elsewhere while they await repairs. "We have no choice. We're stuck here," said homeowner Julie Belfay. Of all the homes CBC visited, Belfay's appeared to be in the worst shape. Belfay, her husband Marcel, and their 2 children moved into the newly built home 2 years ago. They began noticing the problems as soon as they got the keys. On their first day in the house, there was no hot water. A repairman found a valve missing from the tank and water spraying into the insulation. Later, the family noticed a cracked step in a staircase. City inspectors have since confirmed more than 14 building code violations in the Belfay's home, which, according to a municipal property assessment corporation MPAC assessment requested by the couple, has dropped in value by more than $100,000 since they moved in. The assessment took into account construction quality, MPAC said. "It's been hard, it's been very frustrating, causing a lot of anxiety. Sleepless nights," Belfay said. "I'll bet." They've spent thousands of dollars on private engineers and inspectors and countless hours researching and writing to the city, the builder, and Tarion. The process is completely broken, Belface said. People shouldn't suffer this way. The Belfays are not alone. Down the street, 69-year-old William Hillier, and we've heard about him, we hear about him again, who is fighting cancer, said he's also been fighting to have the builder make repairs to his new home. On Christmas Day, Hillier discovered a large puddle of water in his basement when he went to get some extra dishes for dinner. He pulled back the insulation to find a thick sheet of wet ice on the wall. A private contractor later confirmed the Hilliers have mold in the basement of their new home. Hillier, who recently underwent surgery to remove his bladder, said much of his recovery has been spent making calls about repairs to his house. The ordeal is not what the couple expected when they bought the house. It's bad enough dealing with what he's going through. I don't need this on top, Colonette Hillier said. 5 other Cardinal Creek homeowners shared their inspection reports with CBC, but opted not to do interviews out of fear for their property values. Some had also found mold in their homes. I later met the Belfays in person at Queen's Park and raised their story in question period on December 4th, 2018. I asked the government to do something substantive for the Belfays and demanded to know when the government would be reforming Tarion. The newly appointed MGCS minister said he would speak to stakeholders but did not commit to a timetable of reform. Remember, under the previous Liberal government, PC MPPs agreed with the NDP that the need for bold Tarion reform was urgent. What had changed? Why wasn't this a priority for this government? Half a year later, on February 20th, 2019, the same minister appeared in front of a new development in Port Hope and held a press conference where he stated that Tarion was broken. He would be implementing the provision within Bill 166 that Tarion would no longer be both regulator and warranty provider. A Toronto Star article by Tess Kalinowski on this date mentioned that the minister also announced a new round of consultations that will explore whether to break Tarion's monopoly by introducing multi-warranty providers. While making this announcement, the minister was joined by 2 homeowners, Angelo Zeppieri and Krista Schumann, the widow of Dr. Earl Schumann, who took his own life in 2016 after years of battling Tarion to fix the serious defects in his newly built home. We will hear from Ms. Schumann later. This announcement was met with mixed feelings by home warranty reform advocates. Disappointingly, it meant that they would have to wait for real reform as they were subjected to another round of consultation, even after a clear blueprint was laid out by Justice Cunningham years earlier. Furthermore, the language of the minister suggested that if change would come, it might not be as far-reaching as the PCs wanted when they sat in opposition. Following this announcement, I requested and was granted a technical briefing by the Ministry of Government and Consumer Services, who confirmed the minister's announcement. Other than removing Tarion's regulatory functions, the ministry had not decided on what the final solution would look like, nor exactly when it would be implemented. On June 6, 2019, I submitted written questions to the ministry, hoping to gain an update on where the ministry was at on this important file. The questions included whether Tarion's executive and board member salaries would be subject to Sunshine List disclosure, an update on what steps the government is taking to implement the recommendation of the Cunningham report, and comments on the future of Tarion's massive guarantee fund. I never received a response. I continued to remain in constant touch with CPBH, Barbara Kaptein, and the Belfays, and time continued to pass. On August 1st, 2019, CPBH organized a meeting in Cardinal Creek Village to allow homeowners to speak directly to Tarion as well as Ottawa building officials, with the hopes of having the questions answered and concerns met. As official opposition critic for MGCS, I joined my excellent colleague from Ottawa Centre and attended the meeting to hear first-hand accounts from the frustrated homeowners in this still relatively new neighbourhood. It should be noted that the meeting was held by a volunteer advocacy organization rather than the riding's elected officials, although they did show up. Although I had met and spoken with the Belfays on numerous occasions, this was my first visit to their home. It was heart-dropping. It was a heart-dropping experience. I saw the cracks in the foundation. I saw their jackhammered basement floor in order to install the vapor barrier that was never installed during construction. Such a barrier is used to protect against harmful radon gas that emanates from the earth. CBC reporter Laura Osman also attended the home and was as shocked as I was to see such damage to a new home. She released an article to CBC a couple of days later which provided an update on the Belfays fight as well as other Cardinal Creek Village homeowners. But as I returned to Toronto, still feeling the disappointment of what I had now witnessed firsthand, Ontario's Auditor General was putting the finishing touches on a scathing new report of Tarion's practices thanks to that innocuous NDP amendment that slipped through committee a couple of years back. So on October 30th, 2019, the Auditor General, Bonnie Lysyk, released her highly anticipated report on her audit of Tarion. At the outset of her report, the AG confirmed that, and I quote, concerns raised about Tarion's operations were justified. And what is often a person's biggest single purchase in their life was sometimes turned into a frustrating and unnecessarily costly experience because the organization to which the government delegated the responsibility to help them resolve disputes with their new home builder didn't always come through. Tarion's rules in some cases favored builders at the expense of new homeowners. She further noted that, and I quote, the Ontario Home Builders Association, which represents the interests of residential builders, had disproportionate influence over Tarion's decisions and operations. This certainly can explain the skewing of Tarion's rules to favor builders over new home purchasers. She also pointed that Tarion's online builder directory was missing data on builders' poor warranty records and that the laws currently in place in our province are largely ineffective to deter illegal home building. The AG stated that a lack of government oversight resulted in Tarion writing its own rules and regulations with the only avenue of appeal to its decisions was a government tribunal or court action, both of which can be lengthy and costly. In her detailed report, she revealed significant findings of her audit. Most of the following information comes from data she investigated within the 5-year period of 2014 to 2018. So what were some of these findings? Firstly, the AG discovered that 65% of Tarion inspectors attended a new so the AG discovered that 65% of Tarion inspections attending a home warranty complaint confirmed that the builder should have fixed defects under home warranty, but did not. She also discovered that Tarion dismissed almost 10,000 requests within that 5-year period for help due to within that 5-year period due to Tarion's complicated deadlines. For instance, issues that would fall under the 1-year warranty period had to be submitted via form within either the first 30 days of occupancy or the last 30 days of occupancy for the first year. Confusing? About 1,300 of those claims were rejected because they missed the deadline by a single day. What's even more frustrating is that while Tarion has no problem in rejecting claims due to deadlines, they miss their own deadlines almost half of the time. I submitted an amendment to end those 30-day periods in the clause-by-clause meeting for Bill 159 at the Justice Policy Committee on March 2nd of this year. I was shocked to see the government members vote against this sensible amendment. But let's move on. The AG also revealed that Tarion would license builders with poor warranty records, even when homeowners alleged that the builder had acted dishonestly or even broke the law. Furthermore, Tarion's online builder directory did not provide homebuyers with adequate information on builders' warranty history. Talk about a lack of informed consumer choice. So we've heard from the AG on how Tarion dealt with disputes and on their builder licensing. Now let's hear about Tarion's operations. I will quote the AG on this one. Tarion's senior management was rewarded for increasing profits and minimizing financial aid to homeowners. These bonuses were as high as 60% of annual executive salaries. Whoa. She went on to give the example of reducing operating costs as a means of maximizing profits, specifically mentioning Tarion's call center, which, by the way, was determined to provide inaccurate information in 14% of the calls. Not surprising, is it? Does this sound like a consumer protection organization? No. Remember, despite its name, the Tarion Warranty Corporation, Tarion does not actually provide new home warranties. They are there to act as a backstop when builders who are actually responsible for the warranty fail to deliver. Unfortunately, the AG determined that Tarion did not collect enough refundable security deposits from builders to cover the costs of homeowner claims that it might have to pay out. As a result of this, of the money Tarion had to pay out because builders refused to honor their warranties, they were only able to recoup 30% of it. What a tremendous savings for bad builders. The AG also found that Ontario's ombudsperson received 3,000 complaints in the last 10 years. However, issues raised by the ombudsperson were not always resolved by Tarion. One great excuse bad builders could use in not honoring a home warranty was to claim they were not granted entry into a purchaser's home. When such accusations were leveled by builders against their purchasers, the ombudsperson recommended Tarion always confirm this with homeowners directly. The AG discovered they were not doing this in a sample taken in 2018. It's clear who Tarion is siding with, isn't it? Finally, Tarion decided to cancel its yearly in-person public meetings in 2016 after many angry homeowners showed up to a public meeting to complain. Now contrast this with the fact that Tarion has been a large sponsor of the Ontario Home Builder Association's dinner at their annual conference. In the last 5 years alone, Tarion has paid the OHBA $185,000 in dinner sponsorship. I guess they get a much better reception by home builders as compared to home purchasers. Here's an excerpt of the AG's overall conclusion of a report. It goes as follows. Our audit concluded that Tarion's processes and practices do not always conform to the spirit or intent of the Ontario New Home Warranties Plan Act. Tarion lacks effective processes and standards to consistently fulfill its dual mission of enforcing home warranties and regulating builders. Homeowners can lose their legitimate appeal rights for assistance simply by failing to meet Tarion's tight deadlines, even after they have met the timetable for reporting defects to the builder, who is actually the one providing the warranty coverage. The impact of this on homeowners can be enormous as it relates to what is usually the single biggest purchase of their lives. At the same time, builders were not rigorously monitored by Tarion to ensure they operated knowledgeably and with integrity. Some were relicensed to build despite demonstrating problematic behavior, and in some cases, they did not reimburse Tarion for costs incurred to resolve defects before being relicensed. We noted that in more than 4 decades of operation, Tarion has never drafted a builder code of conduct against which builder behavior could be judged. In part, this was due to minimal government oversight of Tarion until very recently, leaving Tarion largely free to determine by itself how it would operate and what rules it would operate under. The only way for a homeowner to appeal to Tarion's decision is through proceedings before the Licensed Appeal Tribunal or through civil litigation, which may cause some to just give up. The AG further elaborates on the uncomfortably close relationship between Tarion and the Ontario Home Builders Association in a section entitled Association Representing Builders Heavily Involved in Tarion Decisions. Now listen very closely. The Ontario Home Builders Association represents the interests of the province's residential home builders. Current Tarion policy requires that 8 of the 16 directors on its boards be members of and nominated by the OHBA. In our 2009 audit titled Consumer Protection, we also reported that Tarion engaged in the unusual practice of allowing an OHBA observer, typically its president, to attend all Tarion board meetings. This practice ended in April 2014, and OHBA observers no longer attend board meetings. We also found that Tarion guidelines stipulate that any proposed changes to its regulations require advanced consultation with the OHBA. The OHBA also has direct access to Tarion's senior management through a liaison committee that meets regularly to discuss proposed changes to regulations in Tarion operations. Speaker, I ask you, what kind of reach do people fighting their warranties have to the senior management of Tarion? But let me get back to this. The OHBA has also created special groups to further discuss specific proposed changes with Tarion. Senior management told us that meetings with the liaison committee took place more regularly in the past, but were held more recently on an ad hoc basis at the call of either Tarion or the OHBA. When we reviewed meeting agendas, we found that a range of topics were discussed, including proposed changes under consideration and discussions about Tarion's operations. We found that this relationship between the Tarion board and the OHBA created an imbalance over the years that favored the interests of builders at the expense of home buyers. For example, some board decisions, such as the implementation of the 30-day submission window, made it difficult for homeowners to access Tarion services when they needed them most, resulting in the denial of thousands of claims. We also found that a number of policies and rules put in place to oversee builders were lenient. For example, Tarion did not for years factor into its licensing decisions any major structural defects caused by builders. It did not recover from builders the compensation it paid out for those defects prior to issuing licensing to them. What could go wrong for home purchasers there, right? Just as Justice Cunningham did in his own review delivered a few short years earlier, the AG offered a series of 30 recommendations. They include recommendations to reduce the influence of home builders on Tarion's board, increase consumer information, eliminate Tarion's confusing deadlines and other needless barriers in making claims, strengthening builder licensing and properly reporting information on their online builder directory. The list of sensible recommendations go on and on. Things now began moving quickly. Tarion was summoned to appear before the Committee of Justice and Policy. At that time, it appeared that both PC and NDP members were once again united on the issue of reform, as Tarion executives were subjected to tough questions. Of course, these were not PC ministers, but rather regular PC MPPs, perhaps not involved at the highest levels of decision-making within their own government. Shortly afterward, Tarion's long-serving CEO, Howard Bogach, retired. On November 13, 2019, I joined NDP leader Andrea Horwath and home warranty reform advocate Barbara Kaptein at Queen's Park, announcing a bold upcoming NDP private members bill that would open up new home warranties in Ontario to competition and would immediately see Tarion taken over by an administrator to make the urgent changes recommended by the Auditor General. Government Omnibus Bill 159 was tabled for first reading on December 5, 2019. I immediately began hearing from reform advocates who were surprised and disappointed to see legislation that did not go far enough. In fact, it would largely rely on Tarion to fix itself. This stood in stark contrast with their position when the PC sat in opposition and certainly went against the spirit of PC members in committee the short weeks earlier. On December 12, 2019, I tabled my private members Bill 169, Home Warranties to Protect Families Act, a bill drafted with real stakeholder input, a bill whose aim first and foremost was consumer protection, a bill that would deliver real change, as envisioned both by Justice Cunningham and the Auditor General, a bill supported by the stakeholders affected by Ontario's problematic system of home warranties, a bill to respect and truly protect new home purchasers. The government decided to travel their Bill 159 in early 2020, giving MPPs a chance to hear from witnesses throughout Ontario, both in person and in writing on these proposed changes. We heard the stories and recommendations of individuals who had issues with builders and Tarion in the past, and stories that were still ongoing. Individuals desperate for help. Many were members of CPBH. Their response was virtually unanimous. In their critique of Bill 159, stating that it did not go far enough to deliver real change to protect new home purchasers. Many were aware Many were aware of my Bill 169 and stated that it would deliver immediate and much-needed improvement to the system. Their comments are available in the Hansard of the Justice Policy Committee. I highly recommend that anyone hoping to improve the system should read them carefully. I will share some of their comments now. Here's an excerpt from Barbara Kaptein in Brampton. I was initially a client of Tarion back in 2011, and after an unfortunate experience with them and with my builder, I decided to try to help other consumers get their homes fixed through the system and to become an advocate for change in the legislation. I've been doing that since 2011. I would like to, in my deputation, tell you why I think Bill 159 is inadequate in the goal that it says it's to achieve, which is to protect consumers. And I would like to propose to you several amendments which I believe would help your bill achieve its stated goal. Your Bill 159 purports to rebuild consumer confidence and strengthen consumer protections relating to the new home warranty and the builder's regulatory body. It fails to do this for several reasons, but I only have time to concentrate on one today, and that is dispute resolution. Dispute resolution has been the key consumer complaint about Tarion for decades. Consumers do not have confidence that their claims are handled in a balanced, transparent, and fair way. They do not have the technical expertise to investigate building defects or the financial resources and lawyers and engineers to support their claims. Tarion holds all the power on investigation, adjudication, and payout decisions, and the ministry has said repeatedly it will not get involved in individual claims. Tarion's dispute resolution process is one of the main conflicts of interest which was pointed out by Justice Cunningham in the 2017 Tarion review. I quote from his report, "There is potential for conflict when the same person receives a claim, investigates it, attempts to assist the parties in resolving the claim, and then sits in judgment on the claim if not resolved." She concluded by asking why government members had now changed course when they so wholeheartedly supported Justice Cunningham's main recommendations when they sat in opposition. In Ottawa, both Marcel and Julie Belfay testified, sharing their personal story and speaking extensively on the entrenched anti-consumer culture of Tarion. Julie said, assuming and believing that Tarion can be fixed is ambitious, When a culture and belief is deep-rooted in an organization, it subconsciously will continue to work within that culture, even after changes are brought forth. First, I can tell you that consumer protection has always been our priority. Howard Bogach, CEO of Tarion. That's what he said. This statement is a clear example of belief in the culture that consumer protection has always been a priority. If it had, we would not be here today. Marcel used his own personal experiences in professional sports when he addressed the entrenched culture of Tarion. When you see a culture change in pro sports, the general manager gets fired. The head coach gets fired. All the coaches go. They only keep the rank and file, which are the players, and even some of those go. You cannot change culture without changing personnel. It just does not work. He stated that the best way to protect consumers is to immediately appoint a senior government official to administrate the program, then go to a multi-provider model, citing that the public is at risk under the current system and have lost confidence in Tarion. He further stated Bill 159 does not address the issues of culture at this corporation. The creation of HICRA and the continuation of Tarion with much of the same leadership will actually embolden the current culture rather than change it. Dave Roberts was a witness in the Ottawa hearing and later sent a written response on his thoughts about Bill 159. His testimony is particularly significant because he joined Tarion as an investigator in 1993 and worked his way up to management, retiring 13 years later in 2017 as Director of Enforcement. He also worked in law enforcement. He was also a building official. Mr. Roberts elaborated on some of his experiences as an inspector. I inspect buildings and have dealt with builders that I wouldn't even allow to build a doghouse for me. Then there are many out there that are great. They're not the ones that are causing problems. They stand by their product. They even will repair stuff that is not warranty related because it's the cost of them doing business and service. Then there's the nickel and dime and the difficult ones, the ones who wash their hands and walk away. Mr. Roberts, former management at Tarion, does not believe Bill 159 goes far enough to improve overall builder quality in Ontario. That is significant. You can't ignore that. During this process, I also had a chance to speak to individuals who work directly for builders. They were rather fearful and insisted on anonymity. One individual said he was kicked off multiple job sites when he pointed out problematic practices that could lead to defects. He said this was a common experience and was concerned about the quality of new home construction. He would not elaborate much further. Another individual was responsible for HVAC installations in new homes. He said that contractors would very often cut corners in the interest of cutting costs, thereby increasing profit. He said that there was always a lot of pressure on tradespeople to install HVAC systems using the least amount of material possible, and a lot of the time these systems were not installed to the specs of the pre-approved drawings. Often, he said, building inspectors don't even check after the actual installation goes in, and as a result, many improperly installed HVAC systems are not discovered until after the homeowner moves in. Conversations like these would put a chill down my spine and speak of a much greater issue that we are barely scratching the surface of here today. But I will have to move on. Following the hearings, Justice Policy Committee reconvened to determine the clause-by-clause of Bill 159 on February 27, 2020. With the benefits of witness testimony, I submitted a series of amendments to Bill 159 that would, 1, disallow any appointments to HICRA, the new regulator, if they had any real or apparent conflict of interest. 2, force HICRA to provide prescribed information on builder noncompliance to municipalities. Think about that. Number 3, cap Tarion executive salaries. 4, appointed administrator to immediately take charge of Tarion to implement immediate and necessary changes. 5, change rules so that the one-year warranty term no longer starts before homes are finished or are even properly habitable. 6, allow home builders to submit claims at any time during the one-year warranty period and abandon the unfair and arbitrary 30-day claim windows. 7, require that Tarion set fair and reasonable timelines for dealing with home buyer claims. Each and every one of these important amendments were voted down by government committee members. A real disappointment. So now, Speaker, I begin the conclusion of my opposition lead here today. Even before Tarion was created, concerns were raised based on its structure and its control by the building industry it was tasked to regulate. But truly, it is not enough to say that the building industry influenced or even controlled Tarion's board, because Tarion's board was the building industry itself. That board hired executive management to action its will. That executive management team hired staff to carry out its work in backstopping warranties and regulating builders, too often with disastrous consequences. To quote the words of the current and former MGCS ministers in this Conservative government, Tarion is broken. Wow. And yet today, we debate a bill that essentially finally enacts elements of Liberal Bill 166, a bill Conservative MPPs until only recently criticized as not going far enough. But these Conservative MPPs are part of a government that takes unquestionable direction from big developers. So this Bill 159 does exactly what the builders wanted to do. That is to leave Tarion to fix itself and keep the status quo as much as possible. You have heard the stakeholders in my submission, knowledgeable people who have taken up the cause of true reform in the regulation of builders and the proper warranties of homes here in Ontario. I cannot thank them enough for their courage, their altruism, and their immensely important work for years. Bill 159 does not satisfy lingering concerns of Tarion's board membership or their new proposed regulatory authority. These new members do not appear to be like the stakeholders whose stories I have shared with you today, stories that once moved and informed members of this Conservative government but are now forgotten. These stakeholders believe Bill 159 does not go far enough. These stakeholders support my own Bill 169, which acts on Justice Cunningham's main recommendations while providing the government with direct control to implement the AG's recommendations immediately. The NDP opposition have in fact tabled 5 new home warranty reform bills. Our most recent one is right here for you on the order paper. The NDP opposition have tried to improve your bill, and you have voted against each and every amendment we proposed. So I leave you with the words of Krista Schumann, the widow of Dr. Earl Schumann, who took his own life in 2016 after battling Tarion for 27 years. Ms. Schumann, who stood beside this government's former MGCS's minister when he said Tarion was broken and announced a plan for change. But here is what she has to say today. Numerous serious issues for consumers with the Tarion warranty program have been ongoing for decades. For 25 years, my husband and other advocates worked to correct the unfair treatment related to construction deficiencies in their newly built homes. My family was hopeful for long overdue change when the 2017 report by Justice Douglas Cunningham and more recently by the Ontario Auditor General Bonnie Lysyk only a few months ago were released. These reports indicate the dysfunction of Tarion because of its monopoly and its preferential treatment of the home building industry over Ontario homeowners, with thousands of legitimate claims ignored and dismissed. The impact of Ontario's government's inaction and its lack of oversight has been devastating for many families. It is extremely disappointing 1 year after the former Minister for Government and Consumer Services announcement of their promise to correct Ontario's new home warranty program, and not enough has been done. Though Bill 159, through Bill 159, the Ontario Conservative government had an opportunity and also a duty to protect Ontario families in the most important purchase that homeowners make. Our government has failed to protect us from building code violations and the impacts on the financial, physical, and mental health of Ontario families, including my own. Government, the ball is in your court.
Question? Order? Order. Question. I recognize the member from Brampton West.
Thank you, Madam Speaker, and thank you to the member from Humber River Black Creek for his remarks. Madam Speaker, our government is listening to the concerns and needs of consumers to help better protect them, and that's why throughout the last year our government has been consulting on three main pillars. That is protecting the privacy of Ontarians, enabling businesses to compete digitally, and enabling better, smarter, and more efficient government. So my question to the member opposite is, does the member opposite understand how important this proposed legislation is in order to protect consumers?
Response, member from Humber River Black Creek.
My response to say is this. The stakeholders know best. They have unequivocally stated in committees, they have inexplicably reached out to each of us, I'm sure individually, they certainly reached out to me, that this Bill 159 provides marginal improvement at best. Stakeholders are asking for real change. NDP members sat in committee. We traveled with you. We offered amendments to improve this legislation. Government members have voted against this. It's disappointing.
Question? Member from Ottawa Centre.
Thank you, Speaker. MPP Rakocevic, thank you very much. That was very, very effective and chilling, because the Cardinal Creek community is in Orleans, and I've spent a lot of time recently in Orleans. I'm wondering if you could tell us a little bit more, given what you saw when both of us went to the Belfoy's home, of what a contrast it must be to walk up a street with these beautiful-looking homes from the outside. But I'm wondering in particular if you could, for the record, talk about the Belfoy's basement and how thin it was from the outside, and how a company like Tamarack can build a home as flawed as the one we saw together.
Response, member from Humber River Black Creek.
I thank you. I thank you. I thank the member for joining me on that visit to the Belfoy family home. It's one thing to hear something. It's one thing to have a phone call to meet someone here in Toronto. It's one thing for them to talk about how their dream of a brand new home became a nightmare. But to go inside their home to see a basement shattered, like an explosion happened in it. To see the reporter that looked, just what we saw, was chilling. It's reprehensible to think about the fact that they are still fighting and that they may never receive what they will have lost. Shame. This system requires massive change.
Jeez. Question, I recognize a member from Mississauga Centre.
Thank you. I would like to thank the member for his speech that was full of emotion. The member and I have traveled throughout Ontario and have talked to a lot of homeowners in Windsor, Ottawa, as well as Brampton.
Was shocking in certain cases. We heard about mold in people's basements, which are a health issue and a health risk. But that is precisely why we are bringing forward this bill, to protect our consumers, to protect our homeowners. And we're changing the culture at Tarion by changing right from the top, from the leadership level. And as you know, we have taken into account Justice Cunningham's recommendations, and we're implementing the majority of them. And same with the Auditor General's recommendations. We are moving on about 29 of those. So I am just surprised why the opposition is not supporting this bill. Thank you.
Response, the member from Humber River Black Creek.
I thank the member for a question. This government is not addressing the issues. This government is asking Tarion to address the issues itself. Tarion, that has existed for over 40 years, who have been rejecting claims and disappointing stakeholders, and in some cases leading to the ruining of lives. I have a bill, Bill 169 in the order paper, that would appoint an administrator immediately to make changes. This government is not following the main recommendations of Justice Cunningham. Main recommendations asked for and supported by the members, the witnesses that showed up in the committee that she was there and that I was there to hear. So they are not enacting the main recommendations of Justice Cunningham, and they have heard, just like I have heard, that this bill does not go far enough in protecting new home purchasers.
Question. I recognize the member from Spadina, Fort York.
Speaker, and I want to thank the member from Humber River Black Creek for a really informative speech this afternoon about home warranties. In my riding, my riding is the waterfront in downtown Toronto. There are many, many condos that are being built, and many people are being hit with surcharges and additional assessments to pay for manufacturing defects in those homes. A friend of mine recently just got hit with an $18,000 assessment to redo the roof, even though the building's only 10 years old. And that's just one, she's just one of many, many tenants. So my question is to the member, will the Conservative changes actually prevent that kind of those kinds of assessments and those kinds of problems in future developments?
Response, the member from Humber River Black Creek.
Thank you very much for the question. We heard resoundingly clearly from individuals that attended committee that this bill doesn't go far enough. We need real change. Tomorrow, people in your own ridings may be purchasing a home or a condo unit and may have to fight tooth and nail to see their own financial future ruined. We heard this. I sat with members in committee. I saw the looks on their faces as they heard these things. I read between the lines of their responses. I heard their questioning of the Tarion itself. You know what the right thing is to do. Reach out to the ministers, reach out to the highest level of governments, and compel them to do the right things. People's lives are depending on it.
Questions? I recognize the member from Mississauga, Erin Mills.
Really, I'm glad to hear from the member, the opposition, that how long that have been on the horizon and never happened. And I'm glad to hear that you acknowledge that our government finally took steps to correct something have been long going on. Our government is addressing 29 recommendations, and the main broken part of Tarion is they represent the regulatory and represent the warranty in the same time. And that was the conflict. And our government moved on and took this regulatory duties off the shelf, off the Tarion mandates. So now Tarion can represent only the home warranty. So my question to the opposite member, yes or no, do you think that this is the best and the biggest change happened to Tarion in the past maybe 15 years? Thank you.
Response, the member from Humber River Black Creek.
This government can continue to believe that they can offer crumbs to people who are starving and tell them it's a loaf of bread. They can continue to create that narrative. Members of this government stood with the NDP when they were in opposition, united against the Liberals. They've changed their story. They've changed their story. They heard what I heard, that this bill does not go far enough. And if members of this government continue to take that narrative, to continue to act like this is massive transformative change, they will only anger the people that they say they're trying to protect. They should consider that as they move forward.
Question. I recognize the member from Toronto St. Paul.
First, I'd like to start by commending the member from Humber River Black Creek for an excellent presentation on why the Government Bill 159, Rebuilding Consumer Confidence Act, does nothing to help the homeowners that are dealing with the issues of Tarion. I'd also like to say thank you to local consumer advocates like Barbara Captain. What I want to ask you, member, can you please let Ontarians know, those that aren't homeowners, if homeowners are paying mortgages while they're living in decrepit houses?
Response, Humber River Black Creek. Quickly.
Thank you, Speaker. This government, and I want to leave them with this, sat in support of NDP efforts to reform Tarion in a meaningful way. We've tried to help you with this bill. The people are counting on you. do the right thing, fix the system in the way it needs to be fixed. Thank you.
Further debate? I recognize a member from Mississauga East Cooksville.
Thank you very much, Madam Speaker. Today, I have the opportunity to speak on a bill that will strengthen protection for consumers, and Bill 159, the Rebuilding Consumer Confidence Act. Madam Speaker, first I would like to thank the Minister for all the great work she is doing in the Ministry of Government and Consumer Services, but also I would like to thank my colleague, the parliamentary assistant, for also contributing towards the great work that the ministry is doing in helping the people of this province. So thank you to both of you. Madam Speaker, our government recognizes the people of Ontario need stronger protections, especially when making some of the biggest investments of their lives, like buying a home. The current system for consumers is simply not enough. That is why, Madam Speaker, our government and the Honourable Minister of Government and Consumer Services have taken the right steps to rebuilding consumers' confidence and protecting Ontarians. Currently, the administration of new home warranties and protections is considered by some to be biased towards builders and potentially neglecting the needs of some consumers. Madam Speaker, we will be changing that. The proposed legislation will strengthen consumer protection and promote trust and confidence for the people of Ontario. Whether they are investing in one of the biggest purchases of their lifetime, a new home, traveling, or making a purchase with their credit card. Madam Speaker, through Bill 159, we are strengthening protection for consumers by proposing more effective enforcement tools to address businesses that continue to cause harm for consumers. The legislation includes a wholesale review of the Consumer Protection Act for the first time in 15 years. That's why, Madam Speaker, Bill 159 is crucial and will aid in strengthening consumer protection in Ontario and give consumers the confidence they need when buying in Ontario. Madam Speaker, we want Ontarians to feel confident and well-informed while having robust protection when they shop online or enter into a contract. That's why our government has taken the right steps to ensure that we deliver on our promises and protect Ontarians. Our government and the Minister have a clear vision, Madam Speaker, for Ontario's consumer, that is to rebuild consumer confidence by offering Ontarians the protections they need at home, online, and in their communities. Throughout 2019, Madam Speaker, our government took a series of measures to strengthen consumer protection in Ontario by cutting red tape, strengthening trust in real estate services, and rebuilding consumer confidence. These are just a few of the many ways we have helped Ontarians and will continue to help and protect them. Madam Speaker, as our world vastly modernizes, so should our laws and legislations. Ontarians need modern protection for how they live today, whether they are booking vacations, using an elevator, or making a purchase with their credit card. Our government has a continued plan to strengthen protections and promote trust and confidence for the people of Ontario. Through Bill 159, we are rebuilding consumer confidence. We are delivering stronger protections to put consumers first. I'm proud to say our government is working hard for the people of this province by modernizing and amending outdated laws for more just and efficient ones. Since our government was elected, Madam Speaker, we have made great strides to strengthen business practices while protecting consumers and keeping Ontario open for business. The people of Ontario need to feel confident that there are strong protections in place when they spend their hard-earned money. That is why the ministry has put forth this robust bill that will help protect Ontarians' hard-earned money. This bill is taking a digital-first approach to deliver stronger protections that are responsive to the needs of consumers while fostering the continued growth of a thriving economy for this province. And as I said earlier, Madam Speaker, I'm extremely proud that the great work that both our minister and parliamentary assistant are doing in regards to this bill. Thank you very much, Madam.
Sorry to interrupt the member but seeing the time on the clock, this House stands adjourned until Monday, March 9th, 2020 at 10:15.